Sorry, my voice is wonky. It's my pleasure to introduce Professor Christof Brandtner, who's an assistant professor of social innovation at Lyon, and he's visiting us for the month. He's published in top journals in both org studies and sociology. He does research on how purpose-driven organizations shape sustainability in cities. But today he'll be presenting on legal cynicism and opioid legislation and how that, how opioid litigation came to be. Right? Thanks, Christof.
And since we are a small group, would it make sense if you briefly introduce yourself so that I know sort of where you're coming from? If you don't mind. Okay, super.
Hi everyone, good afternoon. I'm from Faculty of Laws. Yeah.
I'm Birya, I'm from Faculty of Law.
Hi, I'm Wu Xiaoping. I'm also from Faculty of Law. Yeah.
But I'm really pleased that you're here. My name is Christof. I'm going to tell you a little bit about myself and my research so that you know where this fits in, because I'm not primarily a legal scholar, even though I'm honored that you were here. And then I'll tell you a paper, which actually is a work in progress. We've worked on it for a long time, but we only just now have first full draft. So this is actually right before your suggestions. So I'm happy to let's see. The title of the paper is Institutional Scarring, Local Government Action. In a second. This is co-authored by 4 people who I just want to briefly introduce the other 3 so that you have a sense. Probably appeal to all of you. Amanda Sharkey is in business school, as you probably know, and an organization also. Myself, then there's Katie Young, who is a legal scholar, like a law and society scholar. George Washington University, Amanda is now Notre Dame. And Patrick Bergman at UC Irvine in the business school as well. So the 4 of us have been working on this from sort of different angles, because we all bring different expertise to this paper, as you'll see in a second. And so I come to this from the perspective of an organizational sociologist who is primarily interested in social innovation. What I mean by that is how communities solve social and environmental problems somehow in new ways. I got my undergraduate degree in Vienna, and while I was there, I had an opportunity to study at Hong Kong U for half a year, so before, and I've much appreciated. And after I did that, I went to Stanford to study a sociology program, and I've worked at the University of Chicago, and now there will be more. The work of organizations in the community is called. If any of you have issues hearing, then I'm happy to go to the mic, but I think it's enough. So let me know. So one of the key ideas in my research has been that organizations are crucial components of communities and therefore shape community outcomes. So this work has been central, or sort of it's been emergent, I guess, in sociology more broadly. So for instance, there's been work showing that nonprofit organizations increase crime rates in communities. There's some work that you see here on the long-term consequences of civic capacity, on the ability to withstand crises, such as the Spanish flu, and permafrost in Norway, and some other work related to how people invest shaped by usual. So this is like sort of a new set of studies that I'm interested in. And I've also published this with a specific focus on how nonprofit organizations focus community outcomes, both on the organizational level and on the community level. So for instance, I looked at how COVID-19 policies were adopted faster, they were more proactive nonprofit organizations. And this work that has focused on organizations and their communities often ignores what you probably view as an obvious influence of communities, which is local governments, and the role that they play and their actions play in shaping community outcomes. So for instance, people have studied this in the context of fracking and fracking policies. We've looked at it in the context of other environmental innovations and how they shape governments and sort of the attempt to create just or unjust outcomes. And I've looked at it in the context of green buildings, where I found that local governments often legitimize new practices in communities and make them sort of widely available to organizations that otherwise have no incentives to adopt them. I'm also working on a book titled Cities in Action, which sort of deepens some of these questions. And that's going to be out next year if you're interested in local government. But the general insight of this kind of work has been that local governments often are policy innovators, so they bring new policies to communities, they adopt novel practices, they bring them to the communities, and they often act on behalf of their population in response to certain crises, and they do this by paying attention to institutional influences, including historical influence. This is when it paper fits. What we are looking at here is specifically how local government action is shaped in response to the opioid epidemic. And so you probably have heard of and thought about the opioid epidemic to some degree, because it's all over the media and all over the news. I don't know which one of you has seen or any of these movies or TV shows or read any of these books. Are they on your radar? Yeah, so these are all essentially movies that are about the general story of the opioid epidemic, all great reads. Which is that a certain number of pharmaceutical companies have made it possible for a drug, basically painkillers, to get into the hands of many, many people and destroy their lives. And part of the story is always a company called Purdue Pharma, which was behind the aggressive marketing of this drug, and that benefited financially drastically from this project. This company was founded by Sackler family, which you maybe come across, even though you didn't know. So for instance, just last week, I saw in Beijing, Peking University, the Arthur Sackler Museum of Chinese Archaeology. So they're very, a very, very prominent family that's sort of shaped not only US culture and society, but also around the world. Okay, so this opioid epidemic that I just spoke about has had a massive impact on public health, and it's been described as one of the largest public health crises of the century, or maybe. So the graph that you see here shows annual deaths related to certain causes over time, and you can see that opioid deaths have actually overtaken car accidents in the United States. These deaths include both illicit opioid deaths, so this is heroin addiction most commonly, as well as prescription opioid deaths. So deaths resulting from comorbidities or unintended consequences of prescription painkillers, content, which is what Purdue Pharma produces. So these two, and they often lead to the sorts of addictions that later drive people into heroin addiction. So these two together have overtaken car accidents as one of the major causes of death in the United States. And today, approximately 130 people in the US die every day as a result of opioid-related overdoses. So this is, as I said, a massive public health crisis. And now you might say, well, so interesting this is happening in the United States, but I was actually walking through Chantripur recently and noticed this methadone clinic, which is treating people, who are addicted to heroin just the same way that they exist in the United States. And so you might say, well, this is a minor problem in Hong Kong, and this is probably true because there are only about 3,000 people who are registered as having being heroin addicted or addicted to opioids in general. But I found a paper that argued that these numbers are grossly understated because a lot of people are driven into isolation as a result of opioid addiction and therefore are not registered. So this is right in front of your doorstep basically. Where the consequences of the opioid epidemic can be seen as well. And what's maybe important about this image and this clinic as well is that the costs of the opioid epidemic are not only in terms of how many people died as a result, but also in terms of the cost that they have imposed on local communities. So this method of billing, for instance, has to be paid by someone, and the entities that typically pay for them are local governments. So these are counties in the United States, and the total opioid deaths per 10,000 inhabitants is sort of the total. And as you can see, there's great variation, but there's hardly any community that has people in it that hasn't had, you know, a very significant number of people die from opioid deaths. The red lines around the counties here show what this paper focuses on, which is communities trying to hold Purdue Pharma and other opioid-related companies that benefited from this epidemic accountable for their role in creating the epidemic. So what we're looking at is legal action against the pharmaceutical industry in order to basically get money back for the costs incurred by the crisis. So what I have here is a quote from our interviews from the county attorney of Santa Clara, California, who told us about the very first lawsuit that a local government pursued in order to hold Purdue Pharma accountable. They said, "We're proud to have filed the nation's first government-initiated lawsuit against opioid manufacturers for their role in creating a crisis of opioid addiction, abuse, and overdose death that plagues our communities. We look forward to proving our case at trial, the holding manufacturers accountable, and securing much-needed relief to address an ongoing opioid crisis in our communities." So this happened in 2014. It was the first time that a local government did this. And basically, the idea behind the lawsuits was that opioid manufacturers created a public health nuisance. And they did that by using false advertising, namely saying that their drug is less addictive than other drugs, and you can take it at very high doses without the threat of addiction, but in reality, a lot of people got addicted anyways. Doctors prescribed these at very high rates, but didn't monitor them. So the distributors themselves are also culpable. And finally, pharmacies realized that there were over prescriptions and over ordering opioids, and they did not act on these observations. So all three are culpable for the opioid epidemic in the public health. That was the basic idea of these lawsuits. Now, the 2014 lawsuits were, dormant for a while, or on their own. But in 2017, a number of additional lawsuits became active. And as you can see here, the number has increased to more than half of all counties in the United States. So 56% of counties in the US have, as of today, filed a lawsuit. This red line that I'm showing you is the MDL, is multi-district legislation that basically means that a judge ruled at some point that all of these lawsuits are so similar to each other and are basically pursuing the same idea that they can be consolidated. So at the end of 2017, all of the individual lawsuits of counties were consolidated into a single lawsuit that counties could then join if they didn't want to be treated separately. And you can see here there are three different types or ways in which a county can essentially participate in the lawsuits. One is that the county itself sues Purdue Pharma. Another one is that a major city pursues Purdue Pharma or any related opioid manufacturer, distributor, or that both of them do it together. So what you can see is that the strongest unit that was involved in these lawsuits were indeed counties, which sort of have the benefit of covering the entire population of the US. So every person lives in a county, but not every person lives in a city. So we focus on counties because this is where the majority of these lawsuits happen, but also took into consideration whether a large city within a county has a lawsuit. Okay, so just to show you this, these lawsuits really took off and diffused among cities and counties. And you may have heard about counties. I don't know who was aware of this lawsuit before this law. So this was an unprecedented legal action, as I'll tell you in a second, But there were other types of legal actions that were relatively similar. So this is called affirmative litigation. And there were a number of other forms of government-led affirmative litigation that occurred before this lawsuit of the opioid. The most famous one, the most notable one, is the settlement against the tobacco industry, where basically in the 1990s, the majority of states filed a lawsuit against the largest tobacco manufacturers, and they argued that tobacco firms had caused major harm knowingly and benefited from them financially. This lawsuit was settled, and these tobacco firms had to pay almost $300 billion in settlement money, which was then paid out over a 25-year period to all of the states that were involved in the lawsuit. Okay, I'm gonna get back to this one, but just pointing out that there are a number of other lawsuits that are currently happening that follow the same logic. There is, for instance, affirmative litigation against big oil. California is suing the oil industry for its harms related to climate change. And maybe you've seen just past October, 40 states or over 40 states got together to sue Meta or Facebook for its role in basically proselytizing unrealistic beauty standards among adolescents and children that lead to mental health damages among the children. So they're basically asking for them to pay for again the public health costs that they've created, and this is built directly on the tobacco lawsuits, but a little bit different in terms of being able to prove direct harm. So unclear how this is going to turn out, but it's yet another case where there is affirmative litigation. Okay. What's really unusual about tobacco lawsuits, however, is that it is not states but local governments that pursue these lawsuits. Okay, so traditionally, local government attorney's offices engage in sort of much more defensive forms of litigation. So for instance, they will defend local government jurisdiction against various legal claims. So for instance, if there's a breach of contract, wrongful termination, the violation of civil rights, and they sometimes represent the county in transactional matters, for instance, when they buy a piece of property. Okay, so this is the traditional role that local government attorneys' offices take. This kind of affirmative litigation is much more aggressive because it requires the local governments to initiate the local action where they basically identify a company that they think is violating the law, and they ask to them to be held accountable as plaintiffs. And obviously that requires a different kind of expertise than what local government offices used to have, okay? Because this is actually litigation. In addition, culturally, this is a much more aggressive way of going about enforcing the law than the traditional role in civil litigation. So in other words, the idea that local governments were engaging in this kind of affirmative litigation was really unusual. And it's the first recorded case in which local governments collectively took on this as a role. So the question that we're basically asking is, how is it that local governments initiated legal action against opioid manufacturers, distributors, and retailers? Okay? And so not just a question of why local governments, some local governments did this more than others, but also the general question of why it was local governments to begin with. There are two literatures, sociological literatures primarily, because unlike most of you, I'm a sociologist, as you know. One is the literature on local government action, so basically what explains the diffusion of local government litigation as a practice. And the second, I'll tell you a little more about this in a second. And the second one is the literature on legal consciousness, as you asked earlier, which is about how individuals understand the role of the law and how the law should be interpreted. And in this case, the question is, what is people's understanding of who should hold corporations accountable for causing crises, like in this case, opioid. Any questions so far? All right. So let me tell you a little bit about the literature, but you will see in a second that the literature ended up not being very helpful for understanding this problem. So the first is this literature of local government action, which I am specialized in, where we, so one thing that everybody knows about this literature is that when new practices among local governments spread, it usually happens in two stages. So the first one is that there is a functional reason for a practice to be adopted. So for instance, Harvard and Zucker, who are quoted here, They studied the diffusion of civil service reform in cities in the 1920s. And what they found is that so the civil service reform was meant to basically put appointed city managers at the helm of the city. Why would you do that? Because a lot of cities were so corrupt that you didn't want to have elected people anymore. So basically, that was a response to corruption. And what they found is that indeed, in the first couple of years, the more corrupt cities, people pursued this practice. And so these early adoptions then increase the legitimacy of the practice. So it becomes sort of taken for granted that you participate in this. A lot of cities ended up adopting civil service reform because that's what you do as a good city. That fuels later adoptions, and then functional practice no longer predicted later adoptions. So in the case of the civil service reform, it was states that were proselytizing this idea of structuring local government in a particular form that then became more important than any feature related to the city itself. So one of the crucial questions in this process is how problems become recognized and solved, or sort of what solutions are being proposed. And it's not only local governments that play an important role in this, or political processes, but it often has to do with local political coalitions outside of City Hall. So for instance, when it came to living wage policies, it was often labor unions together with local politicians and non-profit organizations that created momentum for these ideas. Masi and Strang studied these municipal laws that were essentially, they called municipal bills of rights. They're like essentially the idea is to protect the privacy of individuals after the federal government passed the Patriot Act and allowed individual surveillance of individuals. They were basically trying to protect the rights of their citizens. And non-governmental organizations often play a crucial role in this process. You see this also in the context of immigration policies such as sanctuary cities, and in the context of rebuilding policies. So this previous literature is really helpful in understanding why there is local action, but it basically does not explain in any way who takes action. So why it would be local governments rather than states that engage in this. Okay, so it helps with sort of modeling the diffusion a little bit, but it doesn't really help with the answer why it was local governments to begin with. The second literature we drew on was their legal consciousness, which I mentioned before. It's literature in legal science or in society that examines people's attitudes toward willingness to mobilize and suppositions about and experiences of the law. Okay, so the general idea is that people interpret the law in a certain way, and so this literature is about ways in which people do this and come around doing this. It's a cultural process, as someone pointed out, and you've maybe noticed something before, like that in some countries people are much more likely to sue each other over legal disputes. Why is that? Because of their legal consciousness, which is more refined than others. So this is often a precursor to legal action, right? So if you think that the law will be sort of its role is to help you in individual disputes, then you're more likely to. And there's also a lot of more recent work that shows that legal consciousness is relational, which means that it's situated within culture, relationship, social structures. And so we just spoke earlier about Katie Young's paper about Hawaiian cockfighting, and people's understanding of it is sort of shaped by how the police enforce the fact that this is an illegal practice. So this literature is also useful in that it helps us understand what it explains individuals' understanding of the law, but it has never been applied to institutions. So to why a local government office would change its way of thinking about the law, right? And basically switch from defensive to aggressive. How does that happen? Unclear about this literature. So what we did, the empirical approach that we pursued was not to deduce a bunch of hypotheses and then test them, but rather to pursue a full cycle research design. So the idea there is that you combine inductive and deductive methods. You start with the inductive method. In our case, that was doing interviews that help develop explanations basically from the field, but doing interviews with county attorney generals, and then use these in quantitative analyses to test a couple of potential explanations. So basically, it's a combination of quantitative methods to generate an explanation for a phenomenon. which is what we found ourselves happening. And I already mentioned we did semi-structured interviews with county and city attorneys, and then also for event history analyses that predicted when a county adopted the lawsuit, and especially whether that was before the MDL, when it was still difficult to do so. There's more in a second. Okay, so for the interviews, one of our authors, Katie, who's a qualitative legal scholar, as I mentioned, trained a couple of RAs, and they set out to speak to as many county attorney generals as they could. We tried to sample them non-randomly, but to improve or to increase diversity among the sample. So with the intention to speak to as many different representatives as possible, representatives of different counties as possible, in terms of their size, in terms of their politics, in terms of the racial composition and the demographics, and also the extent to which the pandemic hit them. And the response rate was pretty poor, right? And the reason for that is manifold, but one of them is that lawyers really do not like to talk about ongoing litigation, obviously. But in addition to this, this was the beginning of the pandemic, so they really had to answer. Okay, but this 20% response rate was still pretty helpful, and sort of we heard the same things over and over. So in a way, we reached saturation in the interviews with 34 interviews, most of them with city county attorneys and a couple of state attorneys and also private attorneys that were involved in the architecture of these lawsuits. And then we sort of coded them up in order to detect different themes related to opioid litigation, their involvement in the lawsuit, and also the impact of the opioid epidemic in that respect. Okay. Any questions at this point? Otherwise, I'll tell you what we learned from these interviews. I really don't mind if you have questions during the talk, otherwise it's going to be more quick. Hopefully not. Okay, I'll tell you what we learned in the interviews. So the first thing, it will not surprise you because you already saw it in the figure before. The impact of the opioid epidemic is pretty dramatic. An attorney in Tennessee said there is not a single family in this county that hasn't been touched by the opioid crisis. Everybody knows someone. In Montana, somebody said that this crisis strikes across boundaries, right? Like what they also mean is that it doesn't really matter what your income level is or the race of the people involved. Everybody knows somebody who's touched. And then finally, a lot of people mentioned that this devastating toll was really frustrating to people and like made them really upset, in part because they trusted their doctors to prescribe them with medication that would help them. But in fact, there was this reckless overprescription of the drug that led to these negative outcomes, right? So this is not people making bad choices, but it was in fact the distributors, the manufacturers of this drug that caused this outcome. So there's a widespread agreement on this. Now, because of this defensive nature of the offices that I mentioned before, a lot of the local government offices did not really buy with the idea of pursuing aggressive action in this kind of. So they said this is a matter of more aggressive actors, and most of them actually acknowledged that states should be the one to do this kind of thing. So, for instance, in one case in Pennsylvania, the Attorney General mentioned that these counties or that the county was pitched affirmative litigation before, but they decided not to do this because their role is defensive, not aggressive. And one attorney in Washington who, whose county ended up not participating in the lawsuits at all, says that he thinks that these lawsuits are ideologically incorrect. What he meant by that is that affirmative litigation is not the kind of thing that local governments engage in. So this is not right. And so we'll see in a second with ideologically, they don't mean political in terms of party politics, but they mean in terms of the nature, the legal consciousness of the office. Okay. The first thing that came up in a lot of interviews, however, was the tobacco litigation that I mentioned earlier. And the reason for that is that it was, some people noticed that it became clearer and clearer that something is going to happen against the opioid epidemic. There would be some sort of lawsuits, and it was clear that states would be involved. So as early as 2017, when some of the county and city lawsuits also started, but the majority of them, states started fighting. Just like the youth tips that I showed you earlier, lawsuits against Meta, this came out about the opioid epidemic. And for a lot of cities and counties, it became clear that there were going to be lawsuits. And at that point, it was clear that there was going to be, some memories were activated. Okay? So county and city attorneys remembered the big tobacco settlement, and they realized that there were some negative lingering experiences related to tobacco. So what basically happened in these tobacco lawsuits was that the states led the settlement that I mentioned before. And in both cases, there wasn't really a stipulation about how exactly this very large chunk of money was going to be spent. But it was sort of clear that they would, spend it on smoking cessation, basic and prevention. So basically, keeping people away from smoking, because that was the only thing that caused the problem in the first place. But in a lot of states, the states choose to invest this money in totally different things. Literacy program for Colorado, for instance, agriculture, in Kentucky, fixing potholes, right? Like regular issues that the state usually money on. And almost none of this money in some states went to the cities and counties that arguably were bearing the majority of the costs from the public health disaster that smoking had caused. Okay, so a lot of those smoking programs are actually incur money in local governments, just like the methodology that you saw earlier in analogy. But counties didn't see any of this money. Okay, so one attorney said that we didn't get 10 cents out of the tobacco settlement. I think the state distributed it in a way they thought was fair, but it was really frustrating. So this was in New Mexico. Montana, one of the things that influenced us in this case was that when it came down to the tobacco payout, the state took the lion's share of the money, and the county probably didn't get what they were entitled to. So another case where the state kept the tobacco settlement. And a last quote, to me, the state's attorney office is basically saying, hey, you've done shits, and we got a deal for you. We're going to agree to give us all the money from the opioid settlement. And again, there's just out and out distrust because of what the state has done with the tobacco settlement money in the past. So in other words, the counties did not trust the states if they were involved in this opioid in these settlements to redistribute the funds to the counties that actually bore the majority of the costs related to the opioid. So what happened as a result was a change in legal consciousness. So how the counties understood not their own role, but this issue. So they said in light of basically this experience with the tobacco litigation, they thought about affirmative litigation about the opioid epidemic differently than these other issues. The reason is that they actually thought this was a case where basically, if you're not seated at the table, you're what's for dinner. This is sort of one of the frustrations that they expressed. And so a lot of defensive language or protective language emerged in interviews. So for instance, they were saying that what they were doing by joining the lawsuits was to protect the county or to control their own destiny regardless of the state, or to hold prescription companies or drug companies accountable. So the idea was basically that their participation switched from being an aggressive stance to being a defensive stance. They were actually protecting the county from the idea that the state would sue them, then keep all of the money. And they thought that sort of these funds are theirs to keep because they are also the ones that bear the majority of the costs. There were, of course, a number of other issues that we expected to hear, as some of them came up. One of them was just the resources needed in order to pursue an issue like this. So some of the counties said that they were basically just used to handling small money issues, right? Like we said before, like buy a piece of property, but not exactly take down through pharma, rather than these big money issues. And this didn't change. So even now, a lot of them said that they are not a big enough boat, or like they're not large enough to handle this type of litigation on their own. So when Santa Clara and Orange County filed at the very beginning, they were really outliers, and nobody joined because nobody thought that they could stem a lawsuit like this. And so what we learned is that this is highly specialized, very complex litigation, and a lot of counties thought that they could do it on their own. So what happened to a lot of them is that they were actually pitched by outside counsel. So external law firms came to them and they gave them, a pamphlet that said, here's how you join. This lawsuit is happening. And it became relatively easy at one point for counties to join these lawsuits. Importantly, almost every county was approached by some kind of lawyer, right? So this wasn't something that was specifically directed at some counties, but every county in the country, given that there had been zero opioid deaths, they just got one of these in their mail. So basically, the failures to engaging in these lawsuits decreased. And basically it meant that you don't need a ton of money and a ton of expertise in order to do this, but it's enough to participate or to work with one of these law firms or like that. Okay, so after 12 months, as I mentioned, there was this multi-district legislation, which meant there was now this so-called negotiation class where lots of local governments were lumped together in one single lawsuit in like the Northern Ohio district, the Northern District of Ohio, like a single court. And at that point, it became really easy to sign up for these lawsuits, right? So you basically just had to sign a piece of paper and you were on. And there was very little risk related to it as these county attorneys told us. Okay. So the risk calculation changed, but it was generally became lower over time. And we were expecting that we hear a lot about politics because holding a company accountable in general is a deeply political issue. So you heard before, big oil, for instance, is closely tied to climate change, and those are highly political. And our interviewees reported that political divisions were not really the problem. So they didn't only not report these sort of on their own grounds, the way that they didn't talk about the tobacco settlements, but they basically said that political arguments or political considerations were not core to their decision. And as I said before, they thought that this is something that strikes across boundaries, so that it sort of affects everyone. And there were actually a lot of cases which they said, usually we're pretty political office, but in this case we will not, right? So in other words, most of these counties did not consider politics, even though we thought that that was truly going to be a major issue. We're going to get back to this a little bit because we wanted to make sure that that's not the case, because they could have told us anything. But indeed, from the interviews, it seemed like this was not a primarily political. And of course, the relationships between counties or among counties played a major role. So many of them actually got together and discussed their options. And they at times, would do conference calls or webinars or other ways in which they exchange with each other what the options were, especially within states. Whether it would make sense to go after pharmaceutical companies on their own, whether they should wait for the states. Okay, so this is basically what we learned, okay, from these interviews, and now we thought, what can we take out of these interviews that is particularly compelling and based without quantitative data. The thing that struck out to us the most was that the role of the tobacco lawsuits in creating this lingering sense of having been harmed was really interesting and came up as you saw in one of the slides by over half of our respondents on their own. So they brought it up. And so we examined this. We call this an institutional scar, a little bit an analogy to scars of unemployment, for instance, which is the long-term effects of a negative event. And so in this case, the idea of the scar was that because there was this mistrust established between counties and the states, that down the road shaped their decisions, how to make a decision that otherwise might have ended up being different. And so basically this involved some of the reframing that I mentioned, and making this not an aggressive decision or an aggressive stance. Good. Okay. And so basically the question that we wanted to answer with our quantitative data was whether this institutional scarring from tobacco litigation actually affected the likelihood of county survival. And so what did we do to test this? We created the population of all counties in City 5. So we found every single lawsuit that a county was City 5 against pharmaceutical industry, and we started with the MDL, which has both of these cases in it, and went to December 2020. Between September and December, there was no new case. So this is what gets you the N-shaped curve that you saw before, and what's related to the diffusion of a lot of sort of innovations for local action, because it means that at some point we just stop being interested. There were also some county and city findings that were not in the MDL, so we had to go through a variety of different sources to look for lawsuits that were specifically against any of the companies listed in the MDL, and we used Westlaw to basically look for any of the companies as defendants, and then also went again through all of the cases, all of the counties that did not file a lawsuit to check whether they had filed a lawsuit anyways. And basically, it was like a loop of going back and forth between lists of lawsuits and sort of characteristics of lawsuits in order to find all of them. I'm pretty sure that we found every single one of them. We also, at the end, really just sort of Google to see whether counties that we thought should have a lawsuit, but actually all counties that did not have a lawsuit, which means they could potentially still have one, whether they had filed anything. So basically just Googling that for the county and the largest city. So I think this is a relatively comprehensive database that involves, among others, the first date of a filing. I think we were able to see which counties filed sooner rather than later. And the methodological toolkit in order to be able to model something like this is relatively standard. We use the cost proportional asset model. Basically looks at the timing of an event and how different covariates explain when something happens sooner rather than later. And in our case, what we were looking at is whether the lawsuit was filed sooner rather than later. And as I already mentioned, we looked at this institutional so far as one potentially terrible, but we also looked at a variety of other things that kind of as the harm to the county, the geographic spillovers, and the size of the county played, or the capacity and their ability to move, and then partisan politics, which it seems less important in the first. As our independent variable, we were able to draw on data on the spending of the tobacco settlement. So we found what proportion of the settlement money that the state received was directly spent on tobacco cessation and prevention. And this was a non-governmental organization that is sort of like, Center for Tobacco Free Kids, basically like parents against smokers. And they are big tobacco, and they're basically keeping stock of like who, which states spend its money the way in which it was spent. So this is on the state level, counties in states that have a higher percentage spent on smoking and cessation, but we're assuming that they would experience this institutional scar less, right? I mean, basically the state underspends would experience institutional scar more. And in addition to the state level measure, we had some information from two states, in California and New York, that are large enough to actually have initially agreed upon splits between counties within the state. So we also got these two have county level measures for. Okay. And then we have tons of control variables that allow us to test different features of the cities. I'm not going to go into them in detail, but we were able to get monthly opioid deaths per capita from the National Center of Health Statistics, which is difficult to get because they are worried that at some point, you basically can identify which counties were in these statistics, so they didn't want that, and they had to ask for special permission. We did. We also had lots of population characteristics and political dynamics from the Census Bureau and other sources. Familiar with that are pretty standard, and then we looked at a variety of spatial dynamics, spatial distance between counties, a variety of different ways. And we also looked at whether the state had already filed a lawsuit. That would be a major write-up. And then if you're interested in the end, it's sort of alternative explanations, there are many additional robustness checks that were available for everyone in the sample. All right, so let me tell you what we found. We basically went back to this map and tested, do county when did you file a lawsuit or never, and how did this independent variables factor into it, and I'll just tell you what our main findings were. We did find that counties that were stronger hit by the opioid epidemic filed sooner, so no surprise there, but the importance of that variable subsided, it went down over time. So what we did is that we interacted, I think I probably should have mentioned this. We interacted the variables all with whether they mattered more before the MDL, when it's hard to file, or after the MDL, when it becomes very easy to file, right? With the logic being that there is 2 stages of diffusion, and that some of these features should matter more in the first stage. Okay, so being strongly hit matters a great deal, especially early on. That is exactly what we suffered. We saw that the larger locales, larger cities and counties filed earlier, and that high-income counties filed earlier. So the idea here is that those are counties that have great capacity. So they basically were able to pull this off. These are your senators. And we found that Democratic counties did not file earlier. So there was no relationship between, right? No relationship between the politics of the state or the county and whether they file. And there are really strong spatial spillovers, as you probably expected, meaning that if you had a lawsuit in a nearby county, then you were also more likely to file. If you had lawsuits in the state, different counties were also more likely to file. This was one of the strongest effects, of course, unsurprisingly. And as we had hypothesized, the percentage of the settlement that was spent on tobacco-related issues was had a strong effect on the likelihood of filing. So basically, if your state underspent, you were more likely to file, exactly as suggested by the institutes. But this effect became less relevant over time. So there's a statistically significant, especially in the first period before the MDL was established. Okay, so these are the main results. And then we had a number of different robustness checks that I will just mention briefly. One is that we were worried that maybe the fact that states might adjust their tobacco-related spending because they know that new opioid lawsuits are coming. So we also looked at just sort of individual years and how they affect the spending, and that did not make a difference. So it was not a longitudinal variation of patterns in the spending that we saw. We also looked at a difference of an alternative measure of underspending, which is not the percentage of the full settlement, but the percentage of the CDC recommendation. So the CDC recommended to each state how much of these funds they should spend on local tobacco-related issues, and then some states spend more than that, and most states spend less than that. So this is an alternative measure which had the same result. And then finally, as I mentioned, we also had numbers for New York and California on a county level, where we found again a consistent result where lower payments to the county were associated with greater hazard of fire. All right. The last thing I wanted to show is that we also looked at whether this scar effect is driven by what happened right after the tobacco settlement started, because the idea could have been that basically this undermined the capacity to engage in lawsuits down the road, or whether the tobacco funding that is more recent, in recent memory, makes a bigger difference. And it actually turned out that it's a more recent funding that has a bigger effect. So these are not long-term sort of path dependency effects, but this is because this isn't a memory of the attorneys. Okay, let me maybe because we have a second, let me add one more thing about this memory thing. One of the findings that were most interesting to me about the attorneys being so upset about the tobacco lawsuit was not that they themselves had been wrong, but many of them were not actually there during tobacco settlements. This was in the 90s, so most of these people have retired or moved on to different roles. So it was often because the office as such remembered this wrongdoing, right? But they had heard from colleagues that this happened, but it wasn't necessarily personal harm, but it was basically, that's why I say like, this is the recent memory of the institution of having been wronged, 30 years earlier, rather than the individual, sort of individual should be. I think that's important. Okay, so basically what we found is that, especially early on, the institutional scarring and also harm mattered a great deal in motivating these local government lawsuits, and they became less relevant over time. Later on, it's mostly spillovers and also the capacity of the state to engage in this, but generally, civil factors, economic factors became less relevant in predicting who's adopting because a lot of people just signed up to the lawsuit. Partisan politics were not important, maybe were not important. Okay. And obviously there are lots of implications and things that we want to take in the future related to these findings. One is that we the main variable is a state level variable or a county level variable. There's nothing we can do about this, even though we did show you for two states that the effects hold as well. There is one particular process that I think is really crucial, and we think is crucial, but that's difficult to capture, which was this idea of the law firms pitching and how they did this. So I'm actually curious if you are in law school have any thoughts on how to capture this. And then obviously some of the things that happened that we asked people about happened a while ago, or maybe didn't happen at all, such as states not filing. And so that means that some of the interviews may have also been shaped by recency bias. Let me end a couple of notes on what our sort of takeaways are for scholars who are outside of the narrow business of trying to understand these local lawsuits. One is that we think that this idea of institutional scarring is generally a mechanism by which history influences organizations. There is an ever-growing literature trying to understand how history matters and how history influences social and organizational action. And one of the things that people have studied most commonly is how there are positive events in the past that shape capabilities down the road. That they can be used when another event happens. So, for instance, when I mentioned the experience of the Spanish flu or permafrost, these are things that you can benefit from if sort of earlier you had more mutuals before. And so, usually the logic here is that there are positive effects and capabilities rather than negative ones. And I think the SPAR shows how negative emotions and memories can also mobilize experiences way down the road. Then finally, this literature of local government action that I mentioned before has not really looked at legal action at all. And one of the things that we see here is that sort of these cross-level interactions between states and counties played an important role. And finally, in the context of the literature of relational legal consciousness, we think that it's sort of first an interesting finding how attorneys reframed this issue as a defensive rather than an aggressive one, and also to see how sort of legal actions in general are shaped by relational history. So in this case, the relationship between. So we've been working on these. If you have any thoughts on sort of what you do, I would be really interested in some of your ideas. I just want to end on one note, because maybe I gave the impression that local governments fighting these lawsuits is generally a good thing and a better thing than states doing it, because from the perspective of counties, a lot of counties thought that it would be wrong. But I just want to point out that a lot of these funds that are now coming through the first opioid settlements are used on things that are not related to the opioid epidemic either. So, for instance, a lot of the funds from the opioid settlement that we sort of have reports on are actually used to buy police gear. And so, I think it's a very open question whether local governments make better use of these funds than states. If I think about the literacy programs, but that's also an interesting question to discuss. Okay. Well, thank you very much for your patience, and I look forward to your thoughts and anything.
Do you want to moderate, or do you want, oh, well, I guess we can both do it. Oh, yeah, I do. So sorry, my voice is still weird. I have questions, which I guess I can ask her if anyone has a thought, or I can give other, okay, Sida, go ahead.
Thanks so much for the talk. My question is a very simple one, which is I'm having a little trouble kind of thinking about the way you theorize legal consciousness of the state, right, the institutional actor. Because if you look at the literature on legal consciousness, traditionally it's really about the consciousness of individuals, right? How individuals experience law, how they understand law, how they use law, right? But here you're basically saying these institutions, right, the attorney's office or these state institutions actually have a consciousness, right? And they have certain kind of ways they think of law, they use law, and etc. right? So I wonder what is the theoretical payoff of doing that? Vis-a-vis, for example, imagine you could just, do not use the word legal consciousness. You could think about this as a legal strategy of a prosecutor's office, right? Or attorney's office. Or you could use terms like a policy orientation, a shift in their policy orientations toward the opium crisis, right? So what is the benefit? What is the payoff of theorizing this in terms of legal consciousness? Because you're actually making a leap,
Right.
the unit of analysis here.
And not only do we make the leap, but we actually argue that maybe the leap is in itself.
Exactly. Yeah.
So I think if there is another way of referring to an organization's understanding of the law, I would be very open to thinking about it. So you could, maybe this is policy orientation. And maybe the word consciousness isn't great because it refers to the consciousness of an individual. And in this case, we're like sort of assigning, collective consciousness to an organization. It's not really our intention to assume that this maps on directly. But I think what we saw really clearly is that the office has a sort of understanding of its work, right? And a certain understanding of how it fits with the law. So if there is a better term for this, I would be open to using. Given that we have one of the relational consciousness people on our paper, I defer to her to make a decision, and she's happy with our use of it. But I'm really open to thinking about other ways of framing this. Did a specific literature come to mind that you think is better?
Yeah, no, I just, because I mean, let me explain a little more why I asked that. Because if you go back to the original Yu and Silby, book, The Commonplace of Law, I think the way they theorize legal consciousness, really you have the law, you have what they call the commonplace legality, which is something kind of out there in society, right? And then it is kind of internalized, shaped individual legal consciousness. So they clearly have the different unit of analysis in mind when they think about that, right? Right. So I think that's where I think the leap is. But also I think if you look at the literature on organizations, organizational behavior, I think there are also different concepts people use for thinking about these changes. For example, you can think of it in terms of institutional logic, which is a very popular term in business school. I understand it, right? Or like the policy shift or policy. Right. I know. Yeah. But it's, I'm just saying, like, there got to be a compelling reason to use legal consciousness rather than some alternative.
I mean, so the way that I understand logic is like agreement and output sense is that it's, you can rely on different output systems and the different societal understandings. And so you could apply a legal logic rather than say a productive logic, productivity driven on market logic or something like this, right? So market logic and a legal logic could this is not the case here. Like, these are basically two different understandings of the law. And so now you could say, well, these are two different legal logics. But I think that is exactly what led to extreme sprawling of this concept to an extent that it doesn't really make any sense. But I think maybe I don't know. I mean, would you disagree with the idea that that legal consciousness, is a logic even on the individual level?
Well, you can't say it, but I think it's just like I just having a little like confidence, the confidence of the state act, like state. I think it would be actually much easier if you say the legal confidence of for example, the prosecutor, or a state attorney. I think that would be much easier to act with the kind of confidence.
Okay, well, thanks for the feedback. I think that's.
But that's just my bias.
I think that's a legitimate concern. I think the idea of just reducing it to the legal consciousness of the attorney could work. If you take into consideration that, again, the legal consciousness of any one attorney within the county, within the county office is relational rather than individual, right? Like, so these are actually shared consciousnesses within an office. And so not only within an office, but within an institution, meaning all local government offices share a certain logic, if you want, right? Yeah. So you somehow need to capture that aspect as well, because I think that goes beyond the individual nature. But then that might be my bias to think about it as an organizational phenomenon.
But what about collective memory then? Like, how is this different? I hate questions like this, so I wasn't going to ask it, but your conversation is leading me in this direction. But as a thought experiment, how is this different from any finding around collective memory? Like, I don't know, Koreans or Chinese folks feeling wronged by past awful things that Japan did 100 years ago, right? That they didn't live through, and yet they take very personally as relevant, individual and organizational at the national level, parts of their consciousness or logics or whatever, right? Any sort of item of collective memory, and most of it is bad, right? Memories could be understood in this way and work across these levels. Yeah. Because you mentioned memory too in your piece. You went to memory.
This is also how we don't define legal consciousness as individual scarring, right? Like this is
Yeah.
the scar affects
Legal consciousness.
because in this case we specifically look at legal action. So if this were not legal action, then the scar would have an effect with another mechanism, right? So legal consciousness and institutional memory here are not equivalent. But I hear your question as, why do you need to call it institutional scar and not collective memory?
Right.
So that's a fair question. And I think we are trying to get away from thinking about this as, such a high level cultural phenomenon that is like just generally in the ether or in the culture of the country. But we have debated, for instance, national policies that are based on sort of earlier experiences of the state. So I think those are fair questions. I think we're trying to be a little bit more precise than just collective memory, and I think an institutional scar is a very specific kind of memory. That is also not necessarily, as I mentioned, like collective on a country level, right? That we will learn about this in the textbook. Or maybe even in law school, but this is your office where stories are being told about how you were wrong back in the day. So it's not quite on the same level of analysis either. But I would say that institutional scar is a kind of memory. Right?
Yeah.
And maybe there are also other forms, other things that can serve as a scar other than memories, but I haven't really thought about it. Well, as you said, these things like, how is this concept different from this other concept is difficult to answer on the spot, because I think it also requires a bit of really understanding what exactly you mean by collective memory.
Right.
What conceptualization you have in mind, but it's still a good point.
Yeah, no, which is what I wasn't gonna ask, but no, I think it might help just to take into account that lots of people have studied this just in a different way, right? Where you do learn about something that happened to your collective, right? And maybe that's not in the textbook, as you well know the Stanford literature on that. It's not in the textbook, it's in your office, but it somehow feels analogous.
Do you have any specific suggestions for what to look at?
Like in the collective memory stuff? Yeah, I can send you some stuff. Yeah. Jeff Olick, Jeff Alexander, a lot of Jeffs. Yeah, go ahead.
Hi, I'm Li Hui from the Politics and Public Administration Department. I'm very glad I'm here. Very interesting research. So since you study local government diffusion, and one set of literature that I am familiar with, scholars in political science or public administration study, is about diffusion of innovation among local governments. And a classic piece is by Frances Berry and her husband from the Florida State University, right? I don't know if you have read the paper, but they are saying that, right, local government adopted lottery because of several factors, like learning, the competition across different local governments, and the pressure from the state governments, right? So I was thinking, since you are tapping into actually the dynamics between the local and the county and the state government, so maybe you wanted to, maybe it's the different set of literature, because I was thinking, right, from the administration perspective, maybe a more theorization of local and the state government power dynamics would be very interesting. You also said that because your measure of the institutional scarring is actually at the state level. I was actually very confused whether it can account for the scarring effect, right? So I was thinking, well, can you find some data related to the expenditure or the distribution of money between the state and the county government, right?
So that's a great
Mhm.
specific suggestion that I have not really looked at, like the distribution of funds between state and counties in general. I don't know. Yeah, is anything very specific in mind? I think about like how I measure that.
Well, I remember when I was studying local government sustainability adoption, I was looking at the expenditure of state governments, or how much money they give to the county government in terms of the specific different areas. There are data by Urban Institute, I think. Maybe you can take a look. And another question or more comment that I was thinking is, you also mentioned that at the limitation section. So you were saying that the pitching effect of the law firm, right? So I was wondering, well, maybe some local governments, they have never thought about it, but they were invited by this big law firm, and then they thought, why not, right? Because there's no cost involved. So when the law firm was inviting all these county governments to participate in this, do they have a strategy? Like, are they inviting all the local governments, or they are picking out the wealthy, like the Los Angeles County or the New York County? And also, how many county governments actually responded and are motivated by this? Or those who are not asked but decided to participate. So incentive is a little bit different.
That's right. I think that's a good point. That's quickly because I couldn't agree more. I think that that's a really tricky issue, and we try to get at it. But the point is that from the interviews, what we learned is that all of the counties were, contacted. Maybe some were contacted more aggressively. The mobilization strategies may have differed. Some companies may have been more. So one thing you can take into consideration is whether the specific company matters that represented you in the lawsuit, because sometimes this outside counsel is actually visible. That's something that we can look at, but and have to some extent. But in general, there is not that much direct data on this, right? Like, because none of these laws. Maybe the most important thing is that this was not one single big nationwide office, but almost every state had multiple companies engaging in this sort of pitching. So possible that some are more effective than others, but it's really, really difficult to look at. And as I mentioned in interviews, it sort of came out that it was relatively universal. It's still a great issue, and I think it's then the other issue was the existing literature of policy diffusion, we totally spot on, and we proved that many features that are used in, you probably know this, but like the covariates of or correlates of state policy diffusion. So for instance, there are measures of like policy innovativeness, like some states generally tend to adopt certain policies, certain laws sooner than others. Ultimately, so those sorts of things we took into consideration. We took into consideration state level politics, of course, the size of the state, the public health budget of the state. So those are all measures that we were able to account for in control, but we never specifically looked at the relationship between state and county in terms of financial funds. I think a little bit more about this. Maybe we very, it's been a while, but that's another good article. And it sounds like we have some studies in common because of the thoughts.
I was actually, sorry.
Yeah,
I was actually thinking, well, why do you use the state as the unit of county?
No, we would love to use the county, but there is no county level data except for New York and California. And in New York and California we use it. And the results are the same. But these are the only counties where, the only states where county level data is available on how much each county received. In all other states, all you know is how much the states make. So I mean, if there were more county level data, of course, we would love, more binary and better, but it doesn't exist.
I have another question just to give people time to gather their thoughts. My question is persnickety, because I also had a sort of similar dissonance reading how you used legal consciousness. I think similar to what Siddha thought. But to me, it wasn't, I mean, it was about the level of analysis, but to me, what felt interesting or intriguing was that to me, legal consciousness isn't temporal. And what I mean by that is that to me, legal consciousness isn't stable, it's situational, right? So sometimes law is a game and sometimes law is oppressive, and right, the sort of original Uwik and Silby perspective. So making it temporal actually feels like a big conceptual swing that's not contained in the idea of legal consciousness as relational, because ultimately what you're saying is you're telling pragmatists that there's something beyond the situation that matters, right? And that conceptually feels like a bigger swing than what you're selling it as, because you're instead of just elaborating it as an instance of relational legal consciousness. So yeah, I was curious in a way about how you envision the conceptual contribution of the piece.
Sounds more like a very good interjection than a question. I don't know what it is. You're probably right. You were right that situational framework, and it's been developed on an individual level, and it's been developed using ethnographic data which we don't have. So of course it is a stretch, going from this literature to observing it out in the wild and trying to do a quantitative study on it. I don't know if it's big. It sounds like to you do not so much, but maybe to others, right?
Well, I don't think it's just a stretch. I think you could also sell it as a strength, right? Rather than allowing others to call it a stretch, you could go out strong, all guns blazing, and sort of say, look, we're doing something new with this idea of legal consciousness in these ways. I don't know. Yeah, tell Katie that Imwana and Siddha said.
But we do make something of it, right? Like this is one of the three contributions is to think about the way in which the sort of argument that we apply to institutions as well, and whether that's appealing to people who study legal consciousness is another question and answer. Not my special.
Yeah.
We're discussing.
Does anyone else have any other questions? No? Yeah. Okay, great. Then and do you have any other thoughts, Christof? No? Yeah. Thank you, everyone. Great. Thank you so much.
Thank you. And you're also a sociologist, right? Yes, and
We're
we're having. Yeah, we're meeting for much more.